Hello everyone, welcome to Academy of Civil Services. In today's current affairs session, we are discussing the Protection of Human Rights Amendment Act 2019. Basically, we have a National Human Rights Commission for the Center and State Human Rights Commissions for the states in India. The aim of these human rights commissions are securing the human rights for each and every citizen of the nation, whether it is under the state level or the central level, and making investigation if there is any violation of human rights for any section of the population in India. And basically these are the functions of the both Central Human Rights Commission and the State Human Rights Commission. Recently, in 2019, after the new government of India was formed, Parliament of India has passed the National Human Rights Commission Act or the Protection of Human Rights Act 2019. Amendment has been brought. Originally, the National Human Rights Commission and the State Human Rights Commissions were established in 1993 through the original act, that was Protection of Human Rights Act, Human Rights Act 1993. Now, the 1993 Act has been amended in 2019. And in July 2019, President of India Ramnath Kovind has given his assent for the Protection of Human Rights Amendment Act 2019. We can see first why the amendment was required. What was the background reason why the amendment was required? One of the most important reasons was that it was a matter of international shame for India. That is, the Indian National Human Rights Commission of India was not given the A grade. And the grading of international human rights commissions or human rights commissions in different countries is done by the Global Alliance of National Human Rights Institutions. And this Global Alliance of National Human Rights Institutions is the organization which gives international grading and recognition for national human rights commissions of different countries. Unfortunately, in 2017, we were denied the A grade status, and our grade was below A in the grading of the Global Alliance of National Human Rights Institutions. This is a United Nations body, and we wanted to overcome what were the drawbacks Indian human rights, our National Human Rights Commissions had. One of the most important problem was that there was no women in the National Human Rights Commissions. Then the number of women or the representation of women were comparatively lesser in the National Human Rights Commission of India. Then this way, whatever were the problem, because they are grading based on many criteria, and one of the most important are the autonomy, independence and the pluralism. And this is, we have already gone for a Paris Agreement or the Paris Principles of the Human Rights. Based on the Paris Principles of the Human Rights, we have to give enough autonomy for the Human Rights Commissions in India. And whether it is National Human Rights Commission or the State Human Rights Commission, and the commission should be completely independent, and commission should represent the pluralism of the nation, representing each and every section of the country. The commission should be formed. Then these problems were there, some problems related to these three criteria which is followed, which is agreed in the Paris Principles of Human Rights, were lacking in the Indian Human Rights Commission or the National Human Rights Commission as well as the State Human Rights Commission. To address these drawbacks, another important problem was that the qualification to be the head of Human Rights Commission and the state, whether it is National Human Rights or the State Human Rights Commission, was very tough in India. For example, the National Human Rights Commission can be headed only by a retired Chief Justice of India. And sometimes we may not get the Chief Justice of India. Retired Chief Justice should be ready to take over that position. Sometimes we may lack the human resource suitable to be appointed as the head of National Human Rights Commission. Then this way, many complaints started coming up from different states. We are unable to find out a person suitable to be appointed for the higher position in the Human Rights Commission of the state. Then to address these concerns also, we have made certain amendments to Protection of Human Rights Act in 2019 we have made the amendments. The original act was passed in 1993. Now we can see what are the major changes brought by the amendment in 2019. Major amendments we can see first. Amendment related to Chairperson of National Human Rights Commission. National Human Rights Commission Chairperson, the original act of 1993 mentioned that only a person who has been Chief Justice of Supreme Court of India can be. If a person has retired as Chief Justice of the Supreme Court of India, only he can be the chairperson of National Human Rights Commission. And how many retired Chief Justices will be there in the country? Very less number of people will be there. Sometimes that is why government may face a problem in finding out a person suitable or eligible to be appointed as the head of National Human Rights Commission. Because of that, we have relaxed that qualification into either a retired Chief Justice of the Supreme Court or a retired judge of the Supreme Court. Supreme Court of India at present we have 34 judges, that is 1 Chief Justice of India, and 33 judges are there in the Supreme Court in 2019. Recently we have increased the number from 31 to 34. Then total 34 judges we have in the Supreme Court, and many judges are retiring every year, and year to year there is retirement. That is why, and we can get more qualified persons to be appointed as the chairperson of National Human Rights Commission. Then original act mentioned that only a retired Chief Justice of Supreme Court can be the chairperson of National Human Rights Commission, but the amendment in 2019 mentions that either Chief Justice of the Supreme Court or any judge of the Supreme Court who are retired can supervise, can be the head of or chairperson of National Human Rights Commission. And the second amendment in the act is that, another important amendment in the act is that regarding the members of National Human Rights Commission. Original act mentions that one National Human Rights Commissioner, Chief Commissioner would be there, and there should be 2 members also. And these 2 members should be persons having knowledge in the human rights. And out of the members of the membership of the or composition of the National Human Rights Commission, the original act mentions that there should be 2 persons who are experts in the human rights. And here we have changed that 2 persons into 3 persons, and there should be 3 members appointed. Out of the 3 members, why we have made 3 members? We wanted to give the representation for a woman. Out of the 3 members, at least one compulsorily should be a woman. Because when we are giving representation to women, we can manage the pluralism of the commission. And to manage the pluralism of the commission, to maintain the pluralism, and to get the A grade in the global alliance of the national human rights institutions grading, we want to maintain our A grade. For that purpose, we have compulsorily made a clause that one woman expert in human rights must be the member of the National Human Rights Commission. To know more about the National Human Rights Commission, we have covered this chapter in our Indian polity lessons. You can either watch our Indian polity video classes, or you can refer the Academy of Civil Services Indian polity material. There we have a detailed chapter on National Human Rights Commission. Here I am discussing only the amendments made in 2019. That is a current matter, current issue, and there is more probability that this current topic may come in the next year's examination. Now we can go for the 3rd amendment in the National Human Rights and Protection of Human Rights Amendment Act. Ex-officio members. National Human Rights Commission, as I told you, chairperson is there and other members are there. Along with the members, and now we mentioned that 3 members who are expert in human rights are there. Along with that, some chairpersons of some other important commissions are known as the ex officio members of the National Human Rights Commission. Ex officio means that officially the person is the chairperson of National Commission for the Scheduled Caste. Now, extra officially, he is also a member in the National Human Rights Commission. Then we have a ex officio members, few ex officio members as mentioned in 1993 Act. 1993 Act has mentioned that the chairperson of National Commission for Scheduled Caste, chairperson of the National Commission for the Scheduled Caste is an ex officio member in the National Human Rights Commission. Again, chairperson of the National Commission for Scheduled Tribes also, and the chairperson of the National Commission for Women are the ex officio members in the National Human Rights Commission. Now, in 2019 Act, we have added some more members into the category of ex officio members in the National Human Rights Commission. All these members will continue. Chairperson of National Commission for Scheduled Caste, chairperson of National Commission for Scheduled Tribes, chairperson of National Commission for Women, they will be there in the National Human Rights Commission. Along with them, chairperson of the National Commission for the Backward Classes. Recently, by 102nd Amendment Act of Indian Constitution, through the 102nd Amendment Act of Indian Constitution, we have added a new article, Article 338B. And what is Article 338B? Article 338B is the new constitutional body, that is the National Commission for the Backward Classes. National Commission for Backward Classes has been given a constitutional status in 2018 through the 102nd Amendment Act of Indian Constitution in 2018. Now, this National Commission for Backward Classes chairperson would be an ex officio member in the National Commission for Human Rights. And the National Commission for the Protection of the Children's Rights, chairperson of National Commission for the Protection of the Children's Rights will also be an ex officio member in the National Human Rights Commission. Along with that, the Chief Commissioner of the Persons with Disabilities will also be included in the ex officio members category of National Human Rights Commission. Then the category of ex officio members of National Human Rights Commission has been expanded to the chairpersons of certain other constitutional or non-constitutional bodies as well. And this is another important amendment we have brought in 2019. We can see the next amendment. The next amendment is related to the chairperson of State Human Rights Commission. State Human Rights Commission, as I told you earlier, different states were complaining to central government of India that they are unable to get or unable to find out an eligible person or a qualified person to be appointed as the chairperson of State Human Rights Commissions. For the State Human Rights Commissions, the original act mentioned that to be the chairperson of a State Human Rights Commission, and the person should be a retired Chief Justice of a High Court. A person who has been a Chief Justice of a High Court only can be appointed as the chairperson of the State Human Rights Commission. Now, we have expanded that into either the judges, the Supreme Chief Justices of retired Chief Justices of the Supreme High Court, or the retired judges of the High Court. A person who has been Chief Justice of a High Court or the judge of a High Court, either Chief Justice or judge, he has retired either from the position of Chief Justice of a High Court or the judge of a High Court, can be appointed as the chairperson of State Human Rights Commission. Now, moving into the last point, and the last point in the amendment of the Protection of Human Rights Amendment Act 2019 is that term of office for the National Human Rights Commission and the State Human Rights Commission, as the members are, or the chairperson and members mostly are composed of the retired judges of the Supreme Court or High Court. Judges of Supreme Court and High Courts, they retire at the age of 65, and that is why after retirement they are being appointed into the National Human Rights Commission or the State Human Rights Commission. That is why the term or the tenure of the office for the National Human Rights Commission and the State Human Rights Commission in the original act was either 5 years or 70 years of age, whichever is earlier. Either he should be 5 years 5 years if a person is appointed, and if a person is appointed at the 65, 5 years is the up to 70 years, and 5 years or 70 years of age, whichever is earlier. For example, if a person is appointed when he is 67, he will continue only for the 3 years. That was the term mentioned in the original act, and original act also allowed for the reappointment of the members for the National Human Rights Commission or State Human Rights Commission for a period of 5 years. Again, the members can be reappointed, not the chairpersons. Then members can be reappointed for another 5 years term that was given in the original act. In the 2019 Amendment Act, we have made the term into 3 years or 70 years of age. In the term of 5 years has been cut short into 3 years or 70 years of age. Retirement age is same, but the number of years a person can serve in the position of the chairperson or members of both the commissions have been brought down into 3 years or till the age of 70 years, whichever is earlier, and the option for reappointment has been completely removed. A person appointed as a member of the National Human Rights Commission or State Human Rights Commission will have only single term. No question of 5 years again reappointment arises. Then this is another important amendment. We have brought into the Protection of Human Rights Amendment Act 2019. And one more amendment, and that is Commission for the Union Territories. And the earlier one was not the last, was the second last. Anyway, we can take the last one, and that is the Commission for the Union Territories. In the 1993 Act, there was no mention which commission will function for which commission means that what is the status of Union Territories. Whether Union Territories will have a separate Union Territory Human Rights Commission or the Union Territories will come under the National Human Rights Commission. Then we were considering the Union Territories under the National Human Rights Commission because Union Territories are directly ruled by President of India, and Union Territories are because the President of India appoints either the administrator or Lieutenant Governor for administration of Union Territories. Union Territories are completely under the control of Central Government of India. Then the human rights violation cases reported in a Union Territory was taken care of by the National Human Rights Commission. And the problem is that, see, if you are moving to extreme south of India, Andaman and Nicobar Islands, and Andaman and Nicobar Islands, if there is a violation of human rights, the victims of violation have to report to the National Human Rights Commission sitting in Delhi, and sometimes they may have to take a journey up to Delhi. That will be too expensive for a person from extreme south or extreme northeastern part of India also, and from Arunachal Pradesh, a person taking a journey into Delhi for reporting a human rights violation, or a person being summoned by the National Human Rights Commission into Delhi from Arunachal Pradesh or from Lakshadweep, and that will be very difficult for the people. And Arunachal Pradesh, obviously it is not a union territory, it is a state, but I was taking the example there. And now take the case of Andaman and Nicobar Islands, Lakshadweep, Dadra, Nagar Haveli, Daman and Diu, and Ladakh, and these areas, a person coming to Delhi for reporting a violation of human rights by him, we are giving an extra punishment for the victims of human rights violation. Hence, in the 2019 Act, we have made it clear that Central Government of India can decide, can confer on the State Human Rights Commission the functions of the Union Territories. For example, the nearest state for the Union Territory of Lakshadweep is Kerala. Then Central Government can confer on the State Human Rights Commission of Kerala to take care the extra responsibility of taking care of the human rights violations in Lakshadweep as well. And to the Andaman and Nicobar Islands, the nearest city will be Kolkata, and West Bengal, and West Bengal is the nearest state for Andaman and Nicobar Islands, then giving an extra responsibility on the State Human Rights Commission of West Bengal to take care of the human rights violation in Andaman and Nicobar Island can be done by the central government of India. Then central government has been given a power to confer on any state human rights commission the extra charge of the any nearby union territories. And then this is another, and this is the functions of the Delhi, and Delhi, obviously Delhi is closer to National Human Rights Commission. Any human rights violation in Delhi will be taken up by the National Human Rights Commission. And this is the last amendment in the categories of the amendments we brought into Protection of Human Rights Amendment Act in 2019. The original act, as I mentioned you, original act was in 1993. This is the current affairs discussion of today. We are winding up the discussion for today. Stay tuned for the more current affairs or the future daily current affairs updates that will be obviously helpful for your preparation for a UPSC Civil Services Preparation 2020. Thank you for watching and best of luck from Team Academy of Civil Services.